Divorce may change many things in life, but it doesn't necessarily sever your access to valuable Social Security benefits tied to your former spouse. If you were married for at least 10 years, you may have options that could significantly enhance your retirement income without affecting your ex in any way. The truth is, many high net worth divorcees miss out on strategic claiming opportunities simply because they don't know the rules. Today, we're diving into 5 key things every divorced person should understand before filing for Social Security benefits. Spencer, today we are talking about Social Security filing strategies for divorcees. What are some key things we need to know before we even start off on the filing strategies?
Well, first, you need to know that you may be eligible for benefits based on your ex-spouse's earnings history. So there are rules here. Certainly, you need to have been married for 10 years. That's the threshold that if you were married for at least 10 years, then you typically will qualify for their benefits. The other thing you need to know is you don't need their permission or their involvement. So the Social Security Administration makes things really simple from that regard. It's not going to reduce their benefit or increase their benefit. They're not even going to have to sign off to let you have a benefit based on their earnings record. So very simple there. And the other thing to know is just up front, even though you have an earnings record there, you would still qualify for their record. Now, if your earnings history is really high, then that may mean, depending on other circumstances, that you may not be able to tap into benefits based on their earnings history. But just know, even if you have worked throughout the course of your lifetime, that doesn't preclude you from taking advantage of those benefits should other things align.
Okay, that's great. So let's talk about the timing of claiming and how it can affect your benefits. You want to walk us through just some baseline ideas here?
Well, the big picture is that just like any other kind of benefit with Social Security, you are going to have a reduced benefit if you claim early. So let's just say that your ex-spouse had a really strong earnings record and you're approaching the age 62 and you want to file on his or her benefits. The filing at age 62 is going to cut into that lifetime income stream that you will receive. The full retirement age that you have, let's just say that you have a full retirement age of age 67. If you defer to that age, then your benefits will be higher based on that ex-spouse's earnings history. So it's the same thing with your earnings record as that. The other thing that you should know, and we talked about it a little bit, is you can't stack benefits beyond the highest entitlement. So if you have a really high entitlement, it's not as though you could turn on your ex-spouse's benefits at a lower entitlement for a period of time and then switch over to yours. There is a way that you can do that, but not if they're still alive. So okay. we need to be careful with that. The final thing that we'd say is delaying your claiming for the benefit beyond the full retirement age, so age 67 for a lot of folks these days, doesn't increase divorced spouse benefits. And this would be the same with spousal benefits overall. If you're thinking about, okay, when do I claim? Maybe you didn't spend that much time in the workforce. Maybe you spent 15 years in the workforce and your benefit is far less. Your primary insurance amount, your PIA, is far less. If you defer beyond your full retirement age, you don't get those step-up credits beyond that for the spousal benefit or the ex-spousal benefit there. So something to consider if you're going to claim that benefit. No real value of deferring beyond your full retirement age.
Okay, yeah, that's helpful to know. So oftentimes what we'll see is some divorcees will remarry. How does that affect benefits?
Well, it's one of those nuances that we have to be careful with. And we never want to put the cart before the horse here and say, oh, well, you shouldn't get married because of these benefits or what have you. It's a complex decision, but we do just want to lay out the information so that everyone's aware of it. If you remarry prior to the age of 60 in most circumstances, prior to the age of 50 if you are disabled, but in most circumstances prior to the age of 60, if you remarry prior to then and you remain married there, you are not going to have access to an ex-spouse's benefit. So let's just say, again, you get married when you're 25, you divorce when you're 45, you get remarried when you're 55, and now you're 62, still with your second spouse there, married. At age 62, you're not going to be able to file for benefits on first spouse's earnings history there. Whereas in this circumstance, let's say you were married from 25 to 45. Let's just say you were married from 55 to 61 and got divorced then. Well, now at 62, you can look back to your first spouse's earnings history. Of course, your second spouse that you would have been married 6 years to, you would not be able to tap into his or her earnings history there. The additional thing, the plus one here is if you have been married to multiple spouses for 10 years or more. So let's just say that you were married from 25 to 40 to one spouse, from 42 to 57 for another spouse, and now you're at 62, you have two ex-spouses, and you were married to each for at least 10 years, then you could look at either one of their earnings histories there. So lots of different complexity here that sometimes is not appreciated, but can be really helpful for folks.
One thing we haven't covered is divorce survival benefits, and that they may be more generous than spousal benefits. You want to talk us through that?
And this is where things get really interesting, is that if your ex-spouse has passed away, your benefits can be much higher, and your flexibility in claiming them can also be higher. So when we look at this, it's surprising oftentimes to people, but if your ex-spouse has passed away, and let's just say, again, you were married from age 25 to age 40, you were divorced. When you get to age 60, if your ex-spouse passed away a few years prior to that, you could claim his or her full benefit. Now, it would be full benefit, with a haircut, based on early claiming. But let's just say their primary insurance amount was such that they would have a $3,000 monthly benefit. Well, you could tap into that benefit with a haircut at age 60. You could keep taking that benefit for 10 years until you start to tap into your benefit at age 70. So this can be a tremendous value. We've walked through this with a number of different clients who have been quite surprised that they can actually not just tap into that ex-spouse's benefit, but tap into it at a very, very high level. And be able to take that for a period of years. And oftentimes, take it as early as possible and then up until they take their own benefit, again, with some enhanced credits there at age 70.
Right. Yeah, that's really helpful. So the last thing we're going to talk about is any Social Security claiming strategy really needs to be coordinated with broader retirement planning. Why is that?
Well, a few different things here. The first is what we were just talking about. If we coordinate it well, then you can have spousal benefits maybe that start early and defer your own benefits, or we could do the opposite. Actually, we didn't talk about that, but you could claim your own benefits at age 62, then switch over to the spousal benefit at age 67, the deceased spousal benefit that might be quite high if the earnings history was really strong there. So there's lots of different ways that we can structure this where we have an income stream that is strong and steady and growing over time with those cost of living adjustments just within Social Security. The knock-on effect here, though, is that if we get those pieces correct, we can also do some tax planning around them. So if we think about trying to maximize the Social Security benefits, we might be able to do that and have benefits coming along early, which would reduce the amount that we would need to take from other types of investments. Maybe we can just take from non-qualified resources for a period of time and not have to take any IRA resources over time. The key, though, would be then we would want to also explore some Roth converting potentially. So we want to coordinate this to look at the entire trajectory of your tax bill over time. We want to make sure that we're not losing the advantage of maybe doing some conversions early in retirement due to favorable conditions with Social Security. We want to make sure that everything's kind of considered in there together. Now, the thing that we've always got to consider is Social Security benefits are taxed in weird ways via this calculation called provisional income.
Right.
So if you do have Social Security, it may mean that doing Roth conversions early in retirement may not be all that helpful because you may be in one of these areas where Social Security would not be taxed otherwise, and it could be taxed at a much higher level if we start doing some Roth converting. So, we've got to be very aware of all of the moving parts here, and there are a lot of them, but this gives us, for a lot of folks, this is kind of like found money, and We want the found money also to be tax-free if at all possible.
Right. Well, thanks for walking us through those scenarios, Spencer. Clients, if you have any questions about claiming Social Security strategies, if you have gone through a divorce, we would love to have that conversation with you. Until next time, take care. If you like these financial planning videos, please share with a friend, and if you have questions, go to our website at SeriousRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SeriousRetirement.com. The information in this recording is intended for general educational and informational purposes only, and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.